the template training, the trainers, and I have the honor of inviting Professor Lyal Sunga on behalf of the RoL Wallenberg Institute in Sweden to speak on the quote item entitled The Template Training the Trainers. You have the floor.
There. Hello. Good morning, Excellencies, delegations, and all those present today. Today I'll be talking about training the trainers and the background paper and the template. More about the idea as a driving force in terms of enhancing international criminal justice education for the rule of law. First, let me thank the Korean Institute of Criminology and KIC President Park for very kindly bringing me here to contribute to this workshop. Also the RoL Wallenberg Institute, where I'm visiting professor, the RoL Wallenberg Institute of Human Rights and Humanitarian Law in Lund, Sweden, which does a lot of criminal justice training, in fact, as well as the UNODC for coordinating, for help in coordinating the workshop background paper. Now, today I will suggest how to develop international criminal justice education for the rule of law through a training, the trainer's template, and provide a synopsis of this workshop's background paper, which deals with the whole concept. The background paper was developed following a preparatory meeting in Istanbul in September 2009 in close consultation with PNIs and UNODC to propose a training the trainers template, taking into account the discussion guide, regional preparatory meeting outcomes, and UNODC and PNI computer-based and other training. Now, UN crime prevention and criminal justice standards are quite diverse and complex. It is worth noting that the 1996 version of the compendium groups the various instruments in convenient thematic order. You have treatment of prisoners, juvenile justice, alternatives to imprisonment and restorative justice, torture, and capital punishment, basically. Under legal and institutional and practical arrangements for international cooperation, you have model treaties and declarations and plans of actions. Under crime prevention and victims issues, you have crime prevention, victims, violence against women. And then under good governance, the independence of the judiciary, and the integrity of criminal justice personnel, you have a lot of different instruments. Code of conduct, guidelines, basic principles on the independence of the judiciary, and numerous other guidelines and soft law principles in terms of the role of lawyers and prosecutors, public officials, etc. The compendium notes that it compiles instruments developed chiefly under UNODC auspices, rather than those on the administration of criminal justice from, for example, the UN Human Rights Council, or its predecessor, the UN Commission on Human Rights, the special rapporteurs, the various UN human rights treaty bodies, UNHCR, UNICEF, UNDP, or other UN agencies, bodies, or programs. Now that shouldn't be too surprising because UN bodies typically compile and use mainly their own instruments to avoid duplicating documentation from other parts of the UN. But the downside or the disadvantage of this is that it can produce an overly narrow vision of the subject matter. If an institution is using as its main text only instruments relating, developed under its own auspices instead of also those from other areas which relate to the subject matter, it also means possibly that insufficient attention can be paid to relevant norms and standards developed in other UN agencies, bodies, and programs. That may be why, under the torture heading, the compendium lists, the Declaration on the Protection of All Persons from Torture, principles of medical ethics, principles on the effective investigation and documentation of torture, but does not include the most important legally binding multilateral convention on this issue, which is the UN Convention Against Torture. To take another example, the compendium section on capital punishment does not list the second optional protocol to the International Covenant on Civil and Political Rights, which aims at the abolition of the death penalty, or the covenant itself, talking about the International Civil and Political Rights Covenant, despite the relevance of Article 14 to the international legal interpretation of the right to fair trial and to all aspects of the administration of criminal justice. Neither is there any hint in the compendium of the voluminous body of decisions from the general comments of the UN Human Rights Committee or of other UN human rights treaty bodies dealing with administration of criminal justice issues. And criminal justice issues, as we know, involve domestic law, regional standards, transnational criminal law, international human rights law, international humanitarian law, and international criminal law, which each differ in origin, aim, and structure and application, although overlapping to some extent. And they're also distinct in terms of institutional implementation. You have all these different agencies, organs, involved in the implementation of criminal justice. The point of all this is that UN criminal justice norms and standards are highly diverse, even scattered and disorganized, originate from the UNODC and a variety of other non-UNODC sources, are better understood in relation to their purposes and implementation context. Therefore, a more coherent and consolidated approach to international criminal justice, education for the rule of law, should sweep in transnational criminal law and mutual cooperation in criminal matters, regional and international human rights law, UN human rights treaty body recommendations and general comments, also ICRC commentaries, jurisprudence from the International Criminal Court and tribunals and National Truth and Reconciliation Commissions, and successful experiences from computer-based and traditional regional and national approaches. Moreover, international criminal justice education for the rule of law should relate criminal justice to democracy, human rights, and the rule of law, because criminal law without human rights or the rule of law fails justice. And also because criminal law depends also on democratic governance as an important requirement for the effective promotion and protection of human rights and the rule of law. Therefore, international criminal justice education should highlight the conceptual and practical interconnectedness and interdependence among criminal justice and crime prevention, democratic governance, human rights, and the rule of law. It should also maintain prime focus on priorities states themselves have identified as particularly important, particularly developing countries and countries facing the challenges of governance in post-conflict transition and reconstruction. What I'm saying is that UNODC's efforts to strengthen international criminal justice education for the rule of law should focus on where the needs are most urgent, and that means in post-conflict reconstruction and in developing country contexts. And you find the will of states expressed very well in the outcomes, for example, of the international conferences on new or restored democracies that have been going on over the last many years. There's a list of all these conferences. The outcomes of the conferences have declared their particular concern over organized crime, money laundering, drug trafficking, corruption, terrorism, the crime of aggression, war crimes, crimes against humanity and genocide, and the systemic challenge of ensuring civilian control over the military. In short, international criminal justice education for the rule of law has to focus on the main standards and norms contained in the compendium, that's for sure, with special emphasis on the above issues, but also considered in the context of democracy, human rights, and the rule of law. That implies that a training of trainers template should feature a core minimum substantive element focusing mainly on crime prevention and criminal justice topics to ensure quality control in content, but also offer a series of thematic modules to tailor training on particular issues. For example, juvenile justice, capital punishment, women in detention, victims' reparations, etc. So it should be flexible enough to tailor teaching to various stakeholders. There's police officers, armed forces personnel, NGO organization staff, lawyers, prosecutors, judges, etc., national anti-corruption commissions. Moreover, it should highlight the conceptual context of crime prevention and criminal justice, as I said, to the interlinkages among democracy, human rights, and the rule of law, and center around a high-quality training manual designed for training of trainers, workshops, and general use by participants. I just have 2 more slides, almost finished. As proposed in the background paper, so you can see these ideas developed in much more depth in the background paper for this workshop. The template should also use computer, internet, and e-learning to complement traditional lectures and training, workshops, case studies, simulation exercises, and project design sessions. It should also incorporate DVD or CD-ROM format that can supplement and build upon the material covered in the training manual, and take full advantage of UNODC linkages that already exist and are very useful, valuable, such as the Korean Institute of Criminology Virtual Forum Against Cybercrime, the Turkish International Academy Against Drugs and Organized Crime, United Nations Institute for Training and Research e-learning courses, and I could mention also my own institute, the RoL Wallenberg Institute, which has been doing, as I said, much training in criminal justice around the world, as well as build upon existing academic linkages. For example, the Academic Impact Initiative of DPI, the Department of Public Information of the United Nations University, UniCRE, in particular its Master of Laws program, as well as regional Master of Laws programs in human rights that are being taught around the world. Finally, international criminal justice education activities should promote a high level of participant interaction, not only with experts and trainers, but among participants themselves, in order to assist colleagues to learn from each other, not just the trainer.
By yourself, by your country or organization, and pose your question. Thank you. I recognize the representative of the Islamic Republic of Iran.
Thank you, Mr. Chairman. At the outset, allow me to express my deepest gratitude and appreciation for the very and highly constructive and informative information which we received from the esteemed panelists. Due to the constraint of the time, I have 2 questions without identifying the distinguished panelists. Now, we listened carefully to the remarks raised concerning the compendium principles as regards the criminal justice. On the other hand, due to the diversity of these principles, in the draft of the declaration which is going to be adopted at the end of this conference, there is reference to prepare a convention. Then my question would be, what kind of purposes or criteria have been considered as incumbent or maybe mandatory that try to universalize and internationalize these principles, not in a form of soft law, rather in a hard law. If there is any explanation to that extent. And second question is that if there is any study concerning the different benchmarks and criteria when it comes to the criminal justice and civil justice, the criteria which, for example, the burden of proof, or the other which national security, and the other criteria which sometimes should be dealt differently, if there is any study to that regard. Thank you, Mr. Chairman.
Yes, if anybody else wants to comment too, but I'll venture a response. First of all, thanks very much for your very pertinent question. It's a very important one, and I think it could be useful to strengthen international criminal justice education for the rule of law if it's given a solid mandatory basis, because it's a fairly new item that's developing. Whether it comes from a convention or perhaps a resolution, I don't think it makes too much difference, because for me personally, my own personal view is that probably a resolution should be sufficient to strengthen and enhance international criminal justice education for the rule of law on a more universal basis, and to give it the legislative authority, speaking loosely, to get it much more properly anchored in terms of funding and in terms of a more future planned outlook in terms of UNODC's activities. So I think it'd probably be easier to adopt it as a resolution, and to say that that it should be given regular funding support or perhaps voluntary funds to move the project forward and to make a comprehensive template that can be actually developed and implemented. That's all I would say on that point, unless somebody else wants to add something. Thank you.
Thank you, Mr. Chairman. The second question deals with if in case of different criteria as regards the criminal justice and civil justice. For example, when it comes to the burden of proof, when it comes to the widespread or systematic commission of any offenses, if it is criminal or it is civil violation, or for example, when it comes to the cooperation and legal assistance in the criminal matters, we have confronting with many obstacles, for example, national security. Then how could be managed such different views, and if it is possible to have working group, workshops, any study on such different benchmarks and criteria concerning the civil justice administration with criminal justice administration? Thank you.
Thanks again for your follow-on question. I see, I think, a little bit more where you're going, and that is that every country treats the issue of evidentiary questions and also burden of proof differently. As you're saying, there are sometimes some quite variations among countries, how to deal with the difference in terms of procedural differences between criminal law issues and civil law, non-criminal trials. I think UNODC does have some training. I know that also there are other institutions. I think my own institute does some of this, which sets up workshops in cooperation with the government to try to take a look at the domestic law and see whether, for example, in civil trials, whether the burden of proof may be appropriate or not. Or the question that really concerns human rights is sometimes you may have a situation where a case comes under the civil law jurisdiction, but it somehow has penal or quasi-penal consequences. Under administrative law, for example, there may be disciplinary actions. That's where one has to be very careful because, of course, the burden of proof relates very much to the presumption of innocence and also to fair trial in many other areas. So I think you're very much on point to stress this, to emphasize this issue. And I would just join with you, and I would say that I would just, agree with what you're saying, and that it's an important issue. And I think it's one that could be incorporated into workshops through the International Criminal Justice and Education for the Rule of Law, big mouthful, approach to say, look, how does criminal law, where's the dividing line between criminal law and non-criminal law cases, especially where there are disciplinary actions or quasi-penal sanctions? And what does that imply in terms of human rights guarantees, fair trial guarantees, and burden of proof? So I would say your point is very well taken, and if UNODC gets the go-ahead to develop this, I think it is a worthwhile theme that should figure in its template. So thank you very much for your suggestion. I think it's very worthwhile.
Thank you very much, Professor Sunga, for tackling these two complex questions from the representative of Iran. Now I recognize the representative of Kenya.
Thank you, Chairman, and thank you to the eminent presenters for their very illuminating presentations. I have a question to Professor Sunga. There were several regional meetings held which preceded this Congress, particularly on this subject matter, that of criminal justice education for the rule of law. Given the different socio-economic, political, legal, and cultural orientations unique to the developed and developing membership of the UN, and the very complex and diverse United Nations crime prevention and criminal justice standards and norms. What are the practicalities of conducting criminal justice education for the rule of law in a standardized manner? This does not distract from our concurrence with the emerging view that there is need for the development of a conceptually coherent and unified template on this matter? Thank you very much.
Thanks very much. It's a very, very important question that you're raising. And it is a tension that runs through all of what the UN does, as you well know. And also in international human rights law, the standards on the one hand are supposed to be universal. At the same time, there's always a tension that in domestic jurisdiction, the problems are different. People are coming from different cultural, religious, ethnic, historical backgrounds. And sometimes the needs are particular to that country. At the same time, the whole concept of universal standards and some kind of a template is, in a way, very much to draw on best practices, to distill the common elements that come from really actually from national jurisdictions in the first place. Criminal law, I mean, didn't start at the international level. It started at the subnational level, very, very local level, customary systems, tribal systems, in all countries. And it only became national fairly recently, a couple of hundred years ago. So I would agree with you that criminal law matters are very, in some ways, very local, and the problems in terms of implementation are very local. How to address that, that's the point, and that's the question you're asking in terms of universal training. I think it's the same it's the same problem we have in human rights, and that is that the standards themselves, which are developed by member states, were developed very much with a certain amount of inbuilt flexibility, first of all. So universal standards are already not so specific and so precise in any case that they don't apply to some countries. I mean, the more obvious examples are the norms against genocide and war crimes, crimes against humanity, torture, etc. I think we all have to say any country that has the boldness or the audacity to try to accept themselves from that obviously is going in the wrong direction. And that's not what you're saying. What you're saying is, yes, but how can training be made such that it is flexible? And I think that's very much at the heart of what, when I was drafting the background paper and thinking about the template, was very much present in my mind in terms of versatility and flexibility. And that's why in the background paper, the proposal is to have some core minimum standards that address all countries, and these are anti-corruption and norms against genocide and war crimes against humanity, and the other norms against drug trafficking, etc. Nobody would take exception to those. But on the edges, it is important to have, for example, I mean, human trafficking affects more, some countries more than others. Anti-corruption, corruption issues crop up in different ways in different countries. And so a template has the idea is to have a framework to say these standards must be covered, but the way that they're implemented should take very much into account the domestic conditions. And that's up to the trainer to choose the modules, the optional modules that will fit the situation. Number one I should have mentioned would be to be in close consultation with the government. After all, none of this is being imposed or should be imposed upon government. It is offered to member states if they wish to use it. And it's, of course, I would say in the very strong interest of member states to say, oh, yes, we have this tool, but we would like this area addressed more, or we have this particular kind of problem, or we would like to see this issue. And if I were personally working on it, I would say, yes, I would consult with the government first, not just come in with, say, oh, here's the United Nations standards, you have to do this, you have to do that, etc. This doesn't make a lot of sense, and I think I'm very, very, very much sensitive to your point. So just to finish off, the universal standards themselves are flexible, number one. Number two, the template would have optional modules which can be used or not used according to the situation. But third, and most important, is that any international criminal justice education for the rule of law has to be planned from the outset and upon the request of the government concerned, not in any way imposed without such thoroughgoing, close consultation and cooperation with the government. Thank you very much.
Thank you very much, Professor Sunga, once again. And now I recognize
deciding exactly where the support of police forces is required in connection with the army. This, in Mexico, I know, has led to a lot of tension and given a lot of possibilities for assertions of human rights violations. So we recognize Mexico's substantive efforts in the long run. I'm sure there'll be a model for countries in the region. Thank you.
Thanks very much from the Canadian delegation for the question about flexibility in the template and also the role or how would the rule of law be treated there, in what kind of context, and how could it be addressed in terms of training, if I got you correctly. As we all know, I think the rule of law has so many aspects to it, which were mentioned by Bill Chabas in his keynote address, and they're also explored a little bit in the background paper. The concept of integrating democracy, human rights, and the rule of law in terms of context and relating it to crime prevention and criminal justice is to just ensure that the topic is seen in the wider perspective. And in terms of rule of law, as we know, there's so many different aspects to it, but it's important to highlight the doctrinal aspects and how they're interdependent. And this is the way the United Nations has been moving for the last many years, to stress rule of law in the context of human rights and democracy, the democratic governance, and to relate this to criminal justice. So, because the tendency otherwise, if this is why I highlighted in the background paper, without stating that, there's a tendency to go back to the narrow vision and to say, well, we're only going to do these standards that we know, and I think that's not as useful. That's why I'm stressing the context, the connections, doctrinal, and in terms of implementation, that rule of law, democracy, human rights, crime prevention, criminal justice have to be treated together. And what I have in mind in terms of developing a template is to maybe explain that in the outset in terms of an introductory or even an introductory module, because it is of a certain generality in terms of conceptual generality to relate separation of powers, independence of the judiciary, accountability, and all the different aspects of rule of law that are so intermeshed with each other. So that's why that's spelt out in the background paper in that sense. It's in terms of a contextual relation, to not just to focus on crime prevention, criminal justice, in absence of everything else. So I don't know if that answers your question, but that's, thank you very much.
Thank you very much, Professor Sunga. I recognize the delegate. You have the floor, madam.
Thank you, Chair. I'm Mangai Natarajan, Professor and the Director of the International Criminal Justice Program, John Jay College of Criminal Justice. Being part of this, developing this BA and MA program in International Criminal Justice for 15 years or so, and also interested in the crime prevention and criminal justice issues around the world and training police officers in many countries, there is a need for a course to be incorporated in the template on gender sensitization. And I just wanted to comment on that because increasing phenomenon about trafficking of women and children and female victims of different sorts, and dealing with female criminality, and also increasing number of women professionals in the criminal justice system, there is a need for including this course on gender sensitization. There is also a request from many countries on this course, and I just would like to comment on this, and if you have included I would appreciate that.
Sunga, I think once again for you.
Thanks very much for that. In fact, I went through the PowerPoint rather quickly, so it, because of the limited time. But in the background paper, which I hope you'll maybe look at more carefully there, you'll see that gender sensitivity and also, in particular, violence against women issues in terms of the criminal justice framework has to be treated with particular emphasis. And I'm absolutely 100% in agreement with you. I just want to mention also that in my own training with the RoL Wallenberg Institute, the whole emphasis these days is very, very much on the particular concerns that arise in terms of women's human rights, the human rights of women, because we all know that not only in the criminal justice system, but in general, the human rights, respect for human rights is weakest with regard to, in all countries of the world, in all countries, with regard to women. And the other concern is also raised in the background paper with regard to children and certain other vulnerable elements of the vulnerable populations, for example, migrants, disabled persons, etc. But there is a special section there for in terms of how does criminal justice and crime prevention impact the role and status of women and affect their human rights in particular. So very much, I'm 100% with you on it, and that would be reflected as a major theme, not as a subsidiary theme, but as a major theme in the template, because it has to be treated as such. Thanks very much for your excellent point.
Thank you.